Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
So the next thing I want to talk about, we did our copyright, and we have our trademarks. Those are your biggies, okay? If you got nothing out of this today, if I shut this down right now, if you have any artwork that you're using, if you have any manuals, if you have any logos, any trade names, you got to get them registered, okay? Either you do them through a firm like ours, or you do it through a service. Somehow you have to get that done, because those are worth money. That is your brand. Those are the things that you need to protect. Trade secrets we're now going to go into a different category. This has to do with your employees' issues, okay? And I know for a couple of you guys sitting here, I know that's kind of critical. You want to lock that up. The trademarks and copyrights are trade secrets themselves, but they have better protection under the U.S. copyright laws and the trademark laws. The reason I chose to do trade secrets third is because if you locked up the first two, you actually don't even have to go this far. You already have the protection. Whether you had an agreement or not, it doesn't matter, because you own those trademarks and you own those copyrights, right? As a matter of law, you own them, okay? But trade secrets in Illinois, and other states have them, is the best protection, okay? You have protection under the Illinois Trade Secrets Act, even if you have no written agreement, because certain categories of things are considered trade secrets. What is a trade secret? It's defined under that section that I have there. It includes, and there's some others that fall under these similar categories, formulas, okay? Scientific formulas. What else would that be? That could be coding. It could be anything of a scientific nature that you develop. You may also have a patent for that. Our firm doesn't do patent because we're not engineers, but if you have a patent, which is, as you notice, we don't cover that area of it, but that would be something that would be covered under there. Your designs, so the design elements of what you have, it could be the design, it could actually be things like website, your manuals, the way you lay out your stores, for example, the way in which you put up stands, the way in which you teach those processes, those techniques, all of the things that make up your business. What if you were to have a turnkey business, what would you give to somebody that your competitors don't know? Your customer and supplier lists, asterisk, okay? Your customers and suppliers that only you know. The more specialized your industry, the more locked up the private information, the better that they're yours. So for example, in the insurance industry is the best example I can think of. Their client, all that information, like the insured's information and their loss ratios and all this information is locked up and it can't be gotten. You'd have to break into their system, okay? I can imagine maybe in accounting because of the information that you're provided. But if it's anything outside of that kind of very private, even including my own customers. So, you know, like with our clients, providing legal services isn't like some secret, right? It's not some secret of what I do. When I'm practicing law, I didn't make up the laws. I'm just I'm going for it, enforcing your rights. So in the legal profession, you can't even lock us up. Any client can quit at any time. But in other industries where it's much more finite, it gives protections to the owners of those businesses to lock that up, okay? So the main thing with the customer list is to make sure that that's password protected and it's in some kind of a database that they can't get. So if you're allowing your salespeople, for example, to keep their own, what used to be Rolodexes or information on their computers, if they have their own personal computers and it's not locked down and they can take it with them, it's really hard to protect your customers. And it used to be easier, but I'm saying at this point, I'm going to talk about non-competes in a minute, it's virtually impossible to protect it. Virtually impossible, because what it is that you allow them to keep it for themselves, as opposed to saying, this is locked up here, you cannot take it, okay? So again, on this category, that I know that, and that's a big concern for a lot of people, and I know when I say that, it kind of causes some anxiety, but so just kind of keep it in mind. Now, just when I say that, this number two is what I was saying about, for example, my own service. the general public doesn't know and can't know, okay? If your customer is a major customer, okay? So I know, you know, some of our customers are huge customers that everybody has, right? Okay, we do some work for them, or we do a lot of work for them, but everybody knows them. Why? I can literally look them up, and I can find out where they are. You probably don't own the customer anyway. What you do is you might own the contract that you have with them, right? There would be a breach of contract, but the fact that someone can find the point of contact. So for example, the CEO of Sony, I could probably find that pretty easy. And if I call the CEO of Sony and he actually picks up my call, just because somebody else is doing business with Sony doesn't mean I can't do that, right? My chances of getting the business are nil because I don't know anybody there. I just happen to cold haul them, right? So your contracts matter because they give protections. That's why your employment contracts, where it says don't steal my customers, that matters. But bigger picture, if they somehow take it upon themselves to contact this really big customer that everybody knows, it's your business relationship that's going to secure the contract. I like doing business with Ken, for example, as opposed to somebody else, okay? The second thing has to have economic value. So everything in our business doesn't have value, right? So for example, the paper in my office, right? If I wrote a form letter that we use a million different times, it's not a trade secret because it's that. But if if you write something that's very precise, let's say you were doing a breakdown for a client of any given thing, they're like, hey, I have this problem, I need you to do that, and it's your solution to that, and even if you've used it a couple times over, that has economic value because if your competitor could get that, they would be able to do it against you. All your business data is trade secret, right? Anything that your pricing. So I had a huge case years ago where they were competing on this big contract, and the pricing, it all came down to the pricing. The person who had left the company, how could they have known this pricing? As it turned out, it was publicly available. Why? Because it was a public type contract. So it was private until it was made public, in which case then it was not private anymore, right? It's kind of weird. So same thing is if anybody's involved in a public bidding situation at some point in time, you can't protect the pricing because everybody knows it. But if it's privately bid, and now they go and they know you're just a little bit below your competitors and you know what your costs are and they can figure that out, and now they bid against you, that's there even if they never signed a contract. That pricing data was completely protected, okay? And finally, reasonable efforts are made to keep it secret. That's what I'm talking about, locking up with password protection, warnings, policies. Do I have to have them sign an employment handbook this thick? No. But if they're dealing with certain data, even a single page that says you will not take this information, you understand you can't. But the password protect is the way to do that, right? A way that don't let people take stuff home. And I say that very loosely because I know with remote, it's almost impossible, but somehow you have to have a situation where you can track it. So if someone's working remote, you should have some kind of tracking software that shows the in and out of information so that you can and have that monitored. Have your IT professional, for example, who would monitor that and say, hey, just so you know, they started downloading information, right? If someone's going to quit, that's the first thing they're going to do. They're going to download all your stuff because they built your company, right? So Trade Secrets Act's pretty powerful stuff. So the Illinois Trade Secrets Act, when they steal your trade secret, there's a lot of stuff that happens. Injunction, that's your key in all of these things, is to shut them down, to take it back. So when someone violates, for example, you think about the violation of a non-compete, when they take your customers or they're trying to take technology or something like that, you go into court. We'll talk in a minute about some of the nuts and bolts of that, but basically you shut them down with an injunction, which means is you get it back, right? And they can't use it in any way. Misappropriation is the fancy term for theft. Okay, when you take a trade secret, you've misappropriated it, which is to say you took my stuff, okay? So the damage you get are your actual loss. Now, I put competitor's profit on the inside. Sometimes it's your actual loss, meaning what you would have sold and you've actually have a loss of, say 50% of your sales is gone. But what if your sales were the same? What if you actually never suffered anything? You're like, well, I got zero damages. No, it's what they got. So you can get, so their profit, they went from 0 to 50% higher, you can actually get what they earned. So you get the benefit of both sides of that equation. Up to 2 times damage, and there's that willful again, okay? It's almost always willful, just so you know, right? I mean, if someone's doing it, they didn't innocently do it because you told them, okay? Those cease and desist letters, by the way, on willful are very important, even if you don't enforce them, because when you send a cease and desist, what you're telling them is, on this date, I think that you did something bad, and I'm going to do something about it. But maybe you don't do anything about it because it's not worth it, but by having put them on notice, every action thereafter becomes willful because you told them that you had rights and they've thumbed your nose, okay? And later on, they're going to say, well, you didn't take any action. You're like, no, I told you not to. You chose. You're the willful child, right? It's like if you tell your kid, don't grab some cookies, and then they go and they grab the cookies. Yeah, you didn't say, you know, I mean, I know I'm being silly with the kid examples, but it's just, you know, like I said, once you put them on notice, if you intentionally do something, even if innocently, you still did it willfully. Attorney's fees, again, there's that willful, but now here's the thing, this, and I never said this in the other two, but it applies here. If you bring an Illinois trade secrets case in bad faith, you get whacked with attorney's fees. Okay, so it cuts both ways. This is one of the few laws that is, you know, kind of equal opportunity employer, as it were. So if you bring it, you can get the fees, but if you just did it to kind of basically, I'm going to show you, I'm bigger than you, and you know, because you know you couldn't, that's there. Now, I don't want anybody to get scared, like don't be afraid to, you know, file suit against an employee for non-compete violation or something like that. You will have a trade secrets count that's part of that, but I'm talking about a situation where you literally, it was a completely specious lawsuit, like you had no basis whatsoever to do it. It'd be, you know, almost borderline frivolous. Statute of limitations, you got 5 years to enforce it, okay? That's a long time to do that. But you don't have to act right away if they're doing it. You can send the warnings, you can send the cease and desist, you can sit on it for a year or 2 or 3, and you can go after them. Why would you wait? Because they may not have damages early on, and you want to wait and see how they do it. It might peter out. They may not be able to do anything with it. Actually, if you have a good reputation, half the time, you being calm and just keeping relationships will pretty much end most things like that. But occasionally you have a good salesperson who will take everything, and then you got to pick your time. This bottom part is more procedural, but it says it replaces tort, restitution, unfair competition claims. So anything that would be of the same type of misappropriation is going to fall into this act. What it means is that common law cases or your common law similar actions, you don't need them because you got this act. The act gives you more damages than the common law. So they're like, we don't want 2 lawsuits. The way you plead it is actually you plead both. You plead a trade secrets count and you will plead the tort. You have the case dismiss out the tort and say you have a good trade secrets case, you see? But at the end of the day, that's what you'll be with. But it doesn't knock out contracts. So your contract, this is a plus on top of it. You have trade secrets rights regardless. Your contract's going to add on top of that anything else that you want. Criminal actions. So I was telling you about things like the QI-TAM and the Medicare fraud and all those types of things. You can always be sued for criminal anything like that, even though it might have been a theft of secrets. So you can imagine someone stealing from like a huge government contract. And then other claims based on restitution, which really conversion's the only other thing I could even remotely think of. That conversion's like civil theft, but it really doesn't apply for these types of things. And then, as I said at the bottom, if you plead fraud, your worst case scenario is they would say you have the Trade Secrets Act. We're going to go to a jury on a trade secrets violation. You don't need the fraud count because you already get all the damages that come with it. Okay, because fraud isn't going to give you like double damages and stuff like that. If you have intentional fraud, you have willful because the standard is intentional up here, willful, and then negligence. So you can't have you could not have willful and have intentional. Confidentiality, you're like, why is confidentiality so far down the line? Okay, you see, I'm going diminishing returns here. So confidential information includes trade secrets and is less than trade secrets. Okay, so if it's trade secrets, I don't need confidential information. In fact, I don't want anything I'm protecting to be confidential information because that's kind of a catch-all, as I say in the third line there. Okay, so it gives very little protection to unprotectable stuff. Why do people then do confidentiality agreements? Just because I want the backup. You just make them sign it just in case you forgot something or just to give yourself the ability. It's better to sue somebody on a violation of a confidentiality agreement that they signed than to say they took your confidential information. Okay, but again, just to kind of go back to the other one, even if I didn't have this, I always have trade secrets. Okay. The best practice is to define specifically what's confidential data. Okay, so if you've ever done non-disclosure agreements that I've done, They do appear general in nature, and there's a reason for that. But if there's ever a technology that's involved or a specific product or something like that, I'll always say including but not limited to, and I will actually identify by name the specific thing we want to protect, because I'm trying to trigger trade secrets, okay? So if I don't have that, let's assume that I really don't have anything to protect, then you'll go with general confidential information. And usually it's applied to like customer lists and that, and you'll say, well, it was confidential information, they weren't supposed to take it. And then it gets back to that burden of proof thing I was telling you, which was, okay, how did you lock it up? Well, I really didn't do anything. I let them kind of write it in a notepad that they've been keeping for 20 years, these names. And so you see what I'm saying, that it's not confidential because it's publicly available or anybody can get it. But nonetheless, there is value. I just don't, sometimes people get worked up on confidentiality agreements. They signed a confidential agreement, and I'm like, yeah, but what does that mean, okay? It's only as good as what you actually have in your company as being confidential, okay? Now, NDAs, okay? So NDAs are confidentiality agreements, okay? Non-disclosure agreements are important when you're going to buy and sell businesses, when you have your employees, when they sign those with your own customers. I'm not suggesting that NDAs are not good. They are good, and non-disclosure agreements are good. But if there's something precise, again, just make sure that you've identified if there's something that needs to be protected. So, especially if you have like designers, or if you have like people who are doing underlying like software development for you, if there's a particular program they're working on, we might identify that. That gets back to the other issue about like work for hire. You want to make sure that a paragraph is just spelling out you're actually working on this document, and this stuff that you're bringing to the table you get to keep, but this new development is going to be ours. So that type of thing, okay? And then at the very bottom it says non-competes protect against trade secrets and confidential information, but you can't use them in like this broad geographic way. They're not non-competes, okay? It's the data itself that gets protected. It's not where it is. It's because the fact that data left your possession and went somewhere is where the protection is. So it's different from the non-competes. The exception would be like where you're selling a business itself. So non-competes in a business are actually enforceable much more broadly than employees, because the business itself is what's not being competed against. So if I sell my business, all of my assets, all of my accounts to someone, the confidentiality argument goes out the window, the trade secrets does, because they got paid money for something, right? The idea is, hey owner, I just paid you off and you said you wouldn't compete against me, and you just literally opened up another business in the state that you just relocated to, right? That doesn't work, right? Because you basically stole the business that you just sold to them, right? So that's an exception to the rule. That's why in franchise agreements, for example, you'll see the same thing. They have these super broad categories, and the biggest mistake people do is they'll lift non-competes from franchise agreements and they'll put them into individual employee non-compete agreements, and they become completely unenforceable. And they'll say, well, yeah, but the franchisor came after me 3 years ago and they enforced it. And I said, yeah, because it's a franchisor franchisee. It's a business relationship. You're trying to do it against your mid-level salesperson. You guys aren't even in the same category. So it does matter, okay? So non-compete. So now we get to the lowest, and you're like, why did you not start again? We get to the lowest, okay. Copyright your copyrightable stuff. Trademark your trademarkable stuff. Make sure your stuff is identifiable. Trade secrets, lock up it in your agreements as confidential. If you haven't done those four, you're relying on this. If this is your first place that you started, from here on out, this is the last place you go. You don't want to rely on your non-competes, okay? Non-competes will not save your clients. They will not save your customers, because people don't do business with paper. They do business with people. And if they like you, they like you. And if they like your salesperson who's leaving or whoever else, they're going to go with them, okay? The best that you get with the non-competes is you can't prevent business from leaving. It's the damages that you get. If you leave, you will pay, for example, a year of the revenue. A lot of times we'll work out deals where it's like, hey, I want to be able to leave the company, especially like startups. They're like, in the first year, if you leave, you get nothing. If I leave in year 3, I'm going to get 50% of it for 6 months or something like that. That's what you want to use those for. And then you want to say, but you will not go after my contracts themselves. That's the key thing. You don't want someone, so a lot of our contracts, maybe they'll go a year, 3 years, or 5 years. You don't want them going in there and underbidding in the middle of that product. You want to keep that contract, because if you keep the contract, you'll keep the customer, okay? But if the customer, if you're on shaky ground with the customer, they're probably going to eventually leave you. There's nothing you can do about it. You can't like strong arm them, right? But you use that opportunity while you have the contract to kind of keep it going. And there's power to that. So remember, if you have these ongoing customer relationships, that's it. Again, just jumping to the bottom about what's protected, it's the protectable interest and it's near permanent customers. So if you jump up to that right in the middle there, it says virtually unenforceable in volatile industries with high turnover and industries which are low price driven. So volatile industries, like the mortgage industry, is that's a high turnover type of an area. Transportation, drivers is a thing. The over-the-road type of businesses, those are high turnover. Anything that's cost-driven. So really, even if you're selling a product or a part that everybody sells online and it has a range, right? And everybody's in a range, that part of it is not protectable. What it is it's the higher end. It's the service itself, or sometimes like the unique, you have like this smaller category of things. So that's your protectable interest of what they're taking, those contracts, and the near permanent means, how do I know? So if I'll take the mortgage broker thing, if I'm shopping even frankly for insurance, if I go there and I'm like, who can get me the best rate? And someone says, well, I was going to sign them up, they were going to go with me, and you dropped it by half a point or something. Okay, that's just the way it is. It wasn't near permanent because they didn't do business with me because of me. They did business because of the rate. I have to show that they were doing business because of something I bring to the table. So the more specialized an industry, the more likely that's going to be. But even in one where you're doing something that you have other competitors, what is it that you do? For example, do you go to trade shows all the time? Are you out in the community? There's things that you do. I've built my reputation on this particular thing. Maybe you're the only person who actually goes to customer sites all the time, and now they want to take those contracts that you've developed for years. So that's your near permanent type of relationship. The larger the company, the more diverse the company, the harder it's going to be. So if I'm doing business with a large company, even if they have different like local locations, but they report to like a higher up corporate, it's going to be harder to hold on to that because they don't have complete decision-making power. But sometimes you can protect that. In fact, we just wrapped up a suit, and we were defending. I mean, it came out favorable for our client, but that was the issue there, is that this relationship of, it was just a local branch that they were working with at a much larger company, and so that was a central issue about, well, how permanent was that relationship? Okay. So now I'm going to jump up. So who can you, against your employees? Non-competes used to be a thing. I mean, 10 years ago, if I had a non-compete, I could enforce it. I could enforce the 5-mile radius things. I could go in there and enforce it for 2 years. And if they took the contracts, all the better. It was just basically made my life easier. Now it's flip-flopped. As you guys know, the laws are changing every year in the employment setting. So it's basically your highly compensated salespeople or your managers. Your low-level people, your administrative staff are almost, just forget about it, right? Keep them happy. And if they go and they're providing services for you, even if they're doing back office support, they're going to go to somebody else. There's nothing you can do about that. Your salespeople, though, if you're underpaying them, let's say you're paying a salesperson on commission, or you're paying a salesperson on, they're paying like a base salary, $20,000 plus or something. If you're low paying them for whatever reason, and you can't hit that $75,000, and again, it's going to jump up to $80,000 in 2027. If you're not paying them in that range, the laws are written now where it's going to be hard to protect it under the non-compete. You still have the trade secret still. Don't forget, this is completely unrelated, so don't think you're out of the woods. You still have your copyright protections, your trademark. That's why I started with those. Those are all better. If this is what you're relying upon, you got this really now narrow window of people that you're protecting. Same thing with your managers. All of your operations type managers, your sales managers, your all of the people who get involved in the technical side, they know stuff about your company. Those non-competes are going to be enforceable. Just make sure you're paying them like managers, right? If you're paying them like workers, you're running a risk. And then you have to put more time onto your trade secrets and your confidentiality agreements and make sure you get your other things like your trademarks and your copyrights in order, okay? The non-solicitation of employees, which I call rating, because that's really what it is, that's actually a lower amount. That's actually kind of good because Sometimes people can't hurt you with the business, but what they'll do is they'll take your entire sales force and they'll go somewhere else. So you notice that's a much lower. That actually takes into account the lower people who everybody liked, the face of the person who's maybe even the front desk. Unlikely, but it could be that person who always taking the intake. So it's only $45,000 a year that they got to make. So if they're the person who brings the other people in, then that you have that protection as well. And again, the enforceability on sales of businesses and franchises, so the non-competes are much broader. You can lock up like territories and that on the sales of businesses, so if that's a concern. So finally, I told you to talk about litigation. So mediation is something that a year ago I did 40 hours of mediation, and I could have done it a lot sooner than that, but the time was right. I was involved in a lot of huge cases. The attorney's fees were through the roof. The judgments are going up. They're not getting better. I think the sophistication of juries, especially in commercial, there is no sophistication. Because think about the judgments people read about these days. $2 million or $3 million or $5 million that would have been unheard of. People are like, oh, it's just a couple $1 million, you know. They're just making it. They can afford it. So you don't want that to be the case, okay? And strategically, people will send it to juries knowing that they don't know what they're doing. So mediation is always a choice. It can either be part of the contract or it can be part of something that was agreed to. So in a typical case, they take off really quick because of the TRO. So that injunctive relief I was telling you about, temporary restraining orders is the first part of it, okay? You might have heard temporary restraining orders like in a criminal setting. You know, someone was doing something bad to someone, you got a TRO, you can't be within like 100 feet or something like that. In the civil setting, what it means is it's a temporary order that keeps the status quo. So a period of anywhere from 10 to 30 days, it means you can't go sell to these customers, you can't do any of the bad things you're saying, it's just gonna be stuck, okay? Usually you wanna do it because as the person who's having their stuff taken, you need to actually go in there and do damage control. And you don't, because otherwise in 30 days, somebody could basically take your client. Okay, it results in expedited discovery. It means that what would take a year to do discovery will be done in a month. Depositions of all your key people. The early stage literally is as expensive as a trial. You'll try a case in 3 months that would have taken 3 years. All of your business accounts are going to be looked at, and a lot of the judges don't have commercial backgrounds. They come from, they could be divorce attorneys, they could be criminal attorneys, they could be PI attorneys, and so they don't know actually the law. Okay. Mediation allows a streamlined discovery. You can take this big box of stuff and put it here. Experienced mediator, so when I would mediate, it would be anything in the areas that I do in the business sphere so that I know substantively what the law is and know the procedure, and when I tell you that things go a certain way, arguably, I've been there. It makes private what would be public. This is great for not-for-profits. It's great for like religious organizations and that have issues happen that they need to keep private. It allows you can bring in other rules as opposed to like the legal rules. Sometimes there are rules that organizations keep, like their codes of ethics and those types of things that can be integrated. And then the key manager can be limited. You can pick 1 or 2 people as opposed to having 10, okay? So we're coming right to the end of the time, and that leaves open, we got 10 minutes left. We're gonna wrap up at 11:30, but that gives us 10 minutes for questions. And you guys have been great. Actually, I do appreciate the questions because it helps kind of answer it in the moment. But I threw a lot. Hopefully, I hope that the content's good, that some of you guys have kind of a good sense overall of what you need to be thinking about. But is there anything that kind of triggered a question? You're like, you know what? I think the group should hear this question.
Thank you again for watching this informative session. If you have any questions about what you just heard or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclauglin@ma-lawpc.com. Have a wonderful day.